Okay, we're recording broadcast.
Welcome everyone to the Charity and Security Network's webinar on 10 years after the Humanitarian Law Project decision, Fixing the Damage. We are very glad to have such robust response and interest in this issue because of the Supreme Court decision that occurred 10 years ago on June 21st and the damage that it's done, and we want to talk about how we can fix that damage and the efforts that have been made to date along those lines and where things might go in the future. Before we start, also I want to acknowledge that we're holding this webinar on Juneteenth, and given recent events, we're all much more aware of the significance of this date and of the enduring damage that slavery and systemic racism have done in our country, and the need for all of us to not just be aware of it, but to take steps to help correct it going forward and for the next generation. So with that, I'm going to get started by doing kind of a review of what the decision was, and then our experts will talk in more detail about the actual decision and what was held, what the court said, and then we'll have information from the impact and advocacy going forward. So let me get the first slide. So on June 21st, the Supreme Court held that the Congress could constitutionally apply the prohibition on material support to various types of peace-building activities. And the Humanitarian Law Project had challenged the constitutionality of the material support prohibition based on First and Fifth Amendment considerations. Just briefly summarize the decision here so we're all starting in the same place in terms of what the case was about. Humanitarian Law Project wanted to help two foreign terrorist organizations, the Tamil Tigers in Sri Lanka and the PKK in Turkey, on how to use UN conflict resolution processes and other nonviolent means to resolve disputes. The court ruled that Congress can constitutionally prohibit these activities, and that the lack of a requirement to support the intended to further terrorist activities was acceptable. The law only requires one to know the group that they might want to assist is a listed entity, and that intent to support peaceful resolution of conflict, turn a person away from violent extremism is not a defense, and that this is a criminal prohibition that has been incorporated into sanctions programs through executive orders, starting with the post 9/11 Executive Order 13224. So it has had broad implications. Get the next slide. There was widespread criticism of the decision, not just the press conference that the Charity and Security Network held the same day, but also editorials, blogs, and commentary throughout the country, ranging from national press like the Washington Post to the Lexington, Kentucky Herald Leader. Get the next slide. So we immediately began looking for a way to address the impact of this decision because it changed the game for peace building. And we focused on this provision of the Material Support Statute, 18 U.S.C. 2339BJ, which is an exception that allows the Secretary of State, with the concurrence of the Attorney General, to create exemptions to the material support prohibition for non-tangible items, for speech-related items, training, personnel, expert advice, or assistance. So that we focused on this, and with the next slide, show our advocacy efforts. We sent in 2011, 1 year later, after the decision, a letter to Secretary of State Clinton signed by 18 organizations and 27 experts and ambassadors requesting such an exemption and being very specific about what would be exempted: peace-building activities, facilitate dialogue. And discussions of peaceful resolution of differences between parties in armed conflict and support for the logistics necessary to have such dialogue. It's also training, including in-person, written, or virtual presentations and expert advice and assistance in dialogue, aiming at increasing the access to non-combatant civilians under international humanitarian law. It took us 5 months to get the first meeting with the State Department, and the Alliance for Peacebuilding and Sharing Security Network led a small delegation that engaged in negotiations with the State Department on how such an exemption could be structured. A year later, we still weren't there, and another letter was sent from faith leaders requesting Secretary Clinton to move on this. And then after she left office in 2013, we sent a letter to Secretary John Kerry, signed by former government officials and policy experts, including former President Jimmy Carter. The bottom line is that this effort fizzled because we were not able to come to agreement with people at the State Department on how an exemption could work. They were basically taking a zero tolerance approach and concerned that bad actors of some kind could take advantage of an exemption. So next slide, we moved on to Congress. And the 113th Congress, there was the Humanitarian Assistance Facilitation Act was introduced, and this was primarily motivated by the tragedy of the famine in Somalia and the terrible negative impact that counterterrorism restrictions had on the ability of humanitarian organizations to provide assistance. But included in the bill was also a provision that would have addressed the HLC decision. And you'll see here the language: by engaging in any speech or communication with a foreign person subject to sanctions to alleviate suffering of civilian population, including speech or communication to reduce or eliminate the frequency and severity of violent conflict and reducing its impact on the civilian population. The bill did not get a markup in committee. So next slide. We tried again in the 114th Congress with a push for similar legislation elevating the peace-building issue. You see here the primary sponsors of that effort, but we were unable to get a bill filed. And part of what we kept hearing then was no one's been prosecuted for violations, so what are you worried about? And kind of encapsulated the don't ask, don't tell mentality during the Obama administration. So the next slide shows in 2016, this issue came up again. We had provided information to the UN Special Rapporteur on Freedoms of Association and Peaceful Assembly, and in his report, he cited the material support prohibition's impact on peace building, and noting that it may have even been unintended by Congress, and encouraged the government to review the relevant legislation. Next slide. Just summarizes, since 2016, we've continued to work on this issue. We attempted to get the Obama administration to publish guidance before they left office. That failed, but they encouraged us to publish guidance. So we published an analysis of statements made during the oral argument of the HLC case and statements of the government also in their brief, the things that they said were permissible. Even though that doesn't necessarily provide a legal defense, it may indicate where government sees the issue. There's a lot of vagueness that we were left with after the decision. So we, in 2018 through 19, we continued to raise awareness about this issue and looked to the Global Fragility Act, which is then pending in Congress, as an example of a bipartisan solution to the problem that the counterterrorism strategy and framework wasn't focusing on root causes of conflict and needed to change. And the Global Fragility Act, which passed and is now being implemented, pushed things in that direction of changing the overall framework. And so this year, in release of a working paper on implementing the Global Peacebuilding Act, our working group developed language on the need to change the criminal prohibition on material support, and that made it into the working paper on implementation of the Act. That's where we are, and now it's been 10 years, and we still need to deal with the problem that the Supreme Court has created for us. So we are fortunate, very fortunate to have to speak to us today is the lawyer who argues the case in front of the Supreme Court and knows it inside and out. David Cole, then professor of law at Georgetown University and now director of the ACLU legal department. So I'm going to turn it over to him to explain the case in more detail. And also note for people, please use the Q&A bar at the bottom to submit any questions that you have. Thank you.
Thanks, Kay, and thank all of you for joining us. You know, on occasion, Kay will invite me to talk about my loss, you know, every so often. You know, it's not necessarily something I celebrate, but here we are 10 years from the loss in the Supreme Court in the Humanitarian Law Project case. A very, very disappointing decision, and I think one that is in many ways directly contrary to some of the core First Amendment lessons that we learned the hard way during the 1950s in this country. So just to set the stage, I'll go back to the 1950s. And you know, that was the height of the Cold War and the height of McCarthyism and anti-communist measures. And essentially what the Congress and the executive argued back then was that the Communist Party was an international organization. It used illegal ends, including terrorism, to further its goals. And in order to fight it effectively, what we needed was to penalize all those who associate with it, who support it, because that's how you shrink its power and undercut its influence. And after all, it engages in terrorism to further its illegal ends, one of which included overthrowing the United States by force and violence. So, you know, and that argument was widely accepted, so much so that it made its way into the criminal law. It made its way into Truman administration executive loyalty tests of every federal government employee and every employee of any business that did that contracted with the United States, and people lost their jobs and went to jail for being a member of the Communist Party, for having paid dues to the Communist Party, for having subscribed to a communist magazine, or for having been asserted by someone else to be a fellow traveler of the Communist Party. It was a really low point in our history in terms of the application and principle of guilt by association. But as is often the case, the government went too far, and the Army McCarthy era, the Army McCarthy hearings, in which Senator Joe McCarthy was going after members of the Army, people fighting for the defense of this nation, on the ground that they were politically incorrect, that they had communist leanings and the like. It ended up sort of backfiring, and there was a real sort of reaction against it, and a sense that no, you know, when literally millions of Americans have had to go through loyalty oath screenings based on concerns about communism, we have gone too far. And that view was ultimately reflected in Supreme Court decisions, not in congressional action, but in Supreme Court decisions, and in particular, a series of decisions. But the most important one, I think, is a case called United States versus Scales, in which the court held that you can't hold someone responsible, criminally responsible, for their mere association with an organization on the ground that the organization engages in illegal activities, even if it's a foreign organization, the Communist Party, even if there are findings by Congress that it engages in terrorism. To hold somebody responsible for their association with the Communist Party, or their work with the Communist Party, or their support of the Communist Party, or their donations to the Communist Party, simply because the Communist Party engages in illegal activities, violates guilt by association, unless the government can demonstrate that the individual, in joining the Communist Party, supporting the Communist Party, donating to the Communist Party, taking any action in support of the Communist Party, specifically intended to further the illegal ends of the group. So if you work with the Communist Party because you supported its support of civil rights protesters in the South, or if you worked with the Communist Party because you were enamored of its support of labor union activism, legal activities, you could not be penalized, but only if you were actually seeking to further its terrorist activities or its illegal activities could you be penalized. And that's a cornerstone of the First Amendment freedom of association. It's probably the most significant decision protecting the right of association. It's about individual culpability, not guilt by association. So fast forward to the material support statute, passed in 1996, and it makes it a crime to provide material support to terrorist organizations. But significantly, it does not limit its criminal sanctions to support of the terrorist activities of the quote unquote terrorist organization, but instead criminalizes any support provided to the terrorist organization. And any organization can be designated as terrorist as long as it's a foreign organization that in some way, shape, or form has used violence against person or property, and if the Secretary of State concludes that its actions undermine our foreign relations. So it's a very broad definition. Any group, anywhere, that has used violence against person or property can be labeled terrorist by the Secretary of State. And that's basically an unreviewable designation, a labeling. And then once that group is designated, it becomes a crime to provide it with material support, defined broadly to include expert advice, services, training, and personnel, all of which encompass speech. So at that time, the Humanitarian Law Project came to me. I was a lawyer at the Center for Constitutional Rights. They came to me and said, you know, we've been working with the Kurdistan Workers' Party, which represents the Kurds in Turkey, for years in encouraging them to pursue peaceful means to advocate their just cause. They are one of the most abused and discriminated against minority groups in the world, and the Humanitarian Law Project sought to support its cause. The Kurdistan Workers' Party also used violence to further its ends. The Humanitarian Law Project had no truck with that violence, and in fact, its purpose in supporting peaceful and nonviolent ends with the Kurdistan Workers' Party was to direct them in that direction and to, discourage the use of violence. And they did it by working with them in presenting human rights complaints before the UN Human Rights Commission in Geneva, and by helping organize various kind of peacemaking conferences and the like. That was it. But they came to me and they said, well, now this law has been enacted. The Kurdistan Workers' Party has been designated as a terrorist organization. We're worried if we continue to engage in this activity, we could face 10 years in prison under this statute. Can we do it or not? So I read the statute. It seemed to me that there wasn't a clear out under the statute that they could in fact be prosecuted. And I said, there is something you can do, which is you can sue and seek an order from a court saying you have a constitutional right to do this, and so it's unconstitutional for Congress to make it a crime. And we did. So we did. And we sued in California, and for over a decade, we had an injunction issued by the district courts there and affirmed on multiple occasions by the U.S. Court of Appeals out there, saying that it was unconstitutional to apply this law to peacemaking activities, to the advocacy of human rights, and the like. We also represented a number of Tamil organizations that sought to support the Tamils in Sri Lanka, similarly through their peaceful activities. And the Tamil organization in Sri Lanka had also been designated as terrorists. So that was the case. We prevailed repeatedly, but ultimately the Obama administration took the case to the Supreme Court. I argued it there against Elena Kagan. I think it was her second or third argument as Solicitor General for President Obama. We got the ruling, which was a very disappointing ruling. What Chief Justice Roberts said in his ruling for the court was, this is clearly the criminalization of speech. When you make it a crime to provide advice and training about peacemaking or the writing of human rights complaints, that's clearly speech. And when the government makes it a crime to engage in speech, it ordinarily has to satisfy what the court calls strict scrutiny, very demanding justification, and virtually never does a statute satisfy strict scrutiny. The court said this is a criminal. This makes speech criminal. It has to satisfy strict scrutiny, but then it applied the most anemic version of strict scrutiny that I've ever seen, and upheld the law under strict scrutiny. And it said, well, ordinarily, if the government has to show that it's necessary and it's narrowly tailored to further a compelling interest to justify this, here the compelling interest is fighting terrorism. And the plaintiffs argue that you could do it in a more narrowly tailored way by targeting the illegal support for the illegal acts of the group and not criminalizing support for the lawful acts of the group. But this is in the area of, and ordinarily that would be, true, but this is in the area of foreign relations. We have to be very deferential to the president's determinations. And these are foreign organizations, so it's hard. We can't directly control these organizations, and so we have fewer tools available to us to regulate them, and therefore we're going to say it's permissible to make it a crime to engage in pure speech, even if that speech does not seek to further any illegal ends. Very, very disturbing decision. I think roundly condemned not only by the Charity and Security Network and the Lexington Herald and the Washington Post, but by First Amendment scholars across the country and First Amendment organizations across the country, because it sets up a very dangerous precedent, which is that laws that criminalize speech advocating lawful activity can be upheld by the Supreme Court. And in a way, what it does is resurrect the very principle that the court declared unconstitutional in the Communist Party cases, including Scales versus the United States, because it makes it a crime even if you support the organization for its lawful activities, like the Communist Party's civil rights work and labor union work, and even if you have no intention and no effect of furthering the violent activities of the organization. So it's resurrected guilt by association under the rubric of material support. Very, very disturbing decision. Here we are 10 years later, notwithstanding the indefatigable efforts of the Charity and Security Network, we have not had a fix. We have not fixed the damage. And that's very, very disturbing, I think. I'd say a couple of things about that. One is that it is true that the administration has not used this statute to go after, peacemakers. There are, it could enforce the statute more broadly than it has. It has used the statute quite aggressively against Arab and Muslim men who it claims to have supported Al-Qaeda or groups like that. And it likes the statute because it doesn't require the government to prove that the individual actually supported any illegal activity of a group. It makes it a lot easier for them to get a prosecution. And they've gotten lots of convictions under this statute on pretty shaky evidence because the statute is so broad. But they've been, they have not gone after, the peacemakers, so to speak. But I think that is not a sufficient sort of response for a couple of reasons. One is that there is a chilling effect. That the fact that there is a criminal statute out there that has 10-year and more sentences associated with its violation, and that the Supreme Court has said that it's permissible to go after people for engaging in peacemaking, and that even the Obama administration argued that it was constitutional to do that, deters people, understandably, from doing it. I mean, when the Humanitarian Law Project came to me and said, can we do this? I said, well, you could do it, and maybe they wouldn't prosecute you, but if they do prosecute you, you don't have a clear defense, and you could face 10 years in prison. So there's a real chilling effect. Second thing I'll say is that it has had international implications. This model was not only adopted in the United States, but the United States then went out after 9/11 and got the world to adopt it. And so there's tremendous international sanctions regimes that have been challenged in the European Court of Human Rights and many of the European national courts that essentially do the same thing, sometimes with more success than here when it's the challenges. And then third is, and I'll close with this, it is periodically the government sort of holds this up as something we ought to do to domestic organizations. And the most recent was William Barr, the Attorney General, suggesting that Antifa should be designated as a terrorist organization, which would then make anyone who had any connection to Antifa, anyone who supported it in any way, whether they were supporting lawful or unlawful activities, a criminal. And that's obviously a very, very dangerous step if the government starts to designate and blacklist not just foreign organizations, but U.S.-based organizations. So I'll close by just saying that I'm just incredibly indebted to Kay and the Charity and Security Network, and all of you who have worked with that network to try to correct this error. It's sort of I think it's a disaster from First Amendment principle standpoint. It's a loaded weapon sort of laying there that an administration could deploy in very aggressive ways. And it has a tremendous chilling effect on the ability of totally, legitimate organizations to do totally legitimate and honorable work in trying to reduce conflict around the world. Thanks.
Thank you so much, David. Your effort to extend this legal regime to your organization, and we all have to look at it very carefully. Essentially, try to bring the global war on terror home. We don't need it globally. We don't need it at home. And in terms of the effect the decision has had on ongoing peacebuilding work, we're fortunate to be joined by Stacey Schember, the Senior Program Officer at the International Civil Society Action Network. She provides technical assistance on the Better Peace Initiative, the Women's Alliance for Security Leadership, and issues of protection and psychosocial support. and has trained social workers internationally in Ethiopia, Lebanon, India, and other places. She is going to kind of fill us in, not just on how this chilling effect happens, but also how programs have evolved.
Can I get my charger?
Over time. Thank you, Stacey.
Thank you, Kay, for inviting me. And to others as well. I'm delighted to be on this panel. ICANN, the International Civil Society Action Network, spearheads a network of women peace builders called the Women's Alliance for Security Leadership. And we are now at about 70 women-led organizations globally in 40 countries. And they are really on the front lines of doing this work, as David noted, on the ground around the world. Could I have the next slide, please? So I thought I would start by just sharing two personal stories from our partners. One is a peace builder in Sri Lanka, who's one of the founding members of our network. And back during the conflict in Sri Lanka, she was facilitating civil society dialogue with lawyers, doctors, and other professionals. This was a project that was originally funded by the US, and she was questioned as to whether throughout her travels in Sri Lanka, she would have any contact with the LTTE or even have tea with them along the road. And that exchange led to her decision not to continue the work with US funding. She was able to continue it independently, but it's, I think, one of the only projects in her 20 plus years of peace building work that she had to discontinue because of concerns of engaging a terrorist or extremist group. A more recent example comes from Lebanon, where one of our partners there had a signed contract with the State Department to conduct a project on breaking the cycle of extremism. This project involved working with people in prison in Lebanon who were members of violent extremist groups, providing psychosocial support and rehabilitation to them, and then also working with people who had recently been released from prison into the community, providing therapy to them and their families, as well as other skills that would help to reintegrate them into the community. And she received a notice earlier this year that the project was terminated due to circumstances, quote unquote, beyond the control of the NGO. So now she, particularly in this time of COVID, is left without funding and has not been able to initiate or carry forward this work. So the immediate impact in terms of lack of funding to women peace builders and local civil society organizations who frankly are already struggling to access sustainable and flexible funding to conduct their work is one impact or concern to us. Next slide, please. Besides the funding, what are the other impacts? Well, I think, as David alluded to in his remarks, just the impact on how this legislation inhibits or prohibits the kind of peace building work that is happening on the ground is a very severe consequence, because peace builders, just by nature, by the kind of professional work they do, are convening all stakeholders, bringing them to the table, engaging in dialogue and mediation, trying to interrupt cycles of violence, conducting rehabilitation and reintegration work, as I mentioned, and really trying to reweave the social fabric of communities. And when they're not able to build those bridges and to be that bridge between different groups, it really impacts their work and the kind of peace that they're working for on the ground. In addition, when they can't access all members of the community, frankly, it leaves the community more vulnerable in terms of their own safety and security and their vulnerability to recruitment and manipulation by extremist groups. I'd also like to add that I think the legislation, it instills a sense of fear, so that, you know, even if cases are not being brought directly against peace builders, you know, and because of their work, just having that there as a loaded weapon, to use David's term, you know, it adds a sense of undue stress and fear and pressure to peace builders whose work is already quite difficult. And it, you know, while I recognize this legislation was not designed with this intention in mind, it does seem to contribute to the lack of systemic inclusion of civil society and women peace builders, who are really critical partners when thinking about security and foreign policy and the work of counterterrorism and CVE. In many ways, they can be natural allies. And I finally just wanted to mention ICANN's report, Invisible Women, which came out over a year ago. This particular report looked at the gendered aspects of return and reintegration of people from violent extremist groups and impact on their families and communities. And through our extensive consultation and desk review research, we found, just in terms of law and policy, that there was a lack of legal clarity and coherence with regard to the counterterrorism laws, and particularly with this issue of return and rehabilitation. So that's another facet when looking at legislation. And next slide, please. So where are we now? Well, you know, since COVID emerged in the world, at ICANN, we've been having weekly conversations with our WASP partners globally to provide support to them and to, you know, hear directly from them what they're seeing on the ground. Many of them have actually reported an uptick in hate speech, xenophobia, and extremist messaging. And with many fragile and conflict affected countries who already have weakened infrastructure in terms of healthcare and social services, that's very much leaving a vacuum on the ground into which, you know, extremist actors can step in and exploit for their own interests. So our partners have both pre-COVID, and they continue now to be frontline responders in terms of detecting early warning signs and working to prevent and counter extremism. With their access and trust in local communities, they're really well positioned to understand the cultural aspects of this and build counter narratives and take a very holistic approach. So at a time when a lot of funding and support tends to be very siloed and fragmented, by investing in them and supporting them as actors on the ground, we're really ensuring from the local up to the national levels that they can meet the needs of their communities and strengthen the peace building work that they do. Thanks, Kay. I'll stop here.
Thank you. This is frustrating to see how the Humanitarian Law Project decision outcome has put pressure on the potential work of these women peace building organizations, but also very inspiring to see that they're still hanging in there. They're still doing what they can, and that potential, if we can come up with a fix, at least that potential could really have a huge positive impact. So where do we go from here? Next, we're going to hear from Liz Hume, Vice President of the Alliance for Peace Building, and also former senior level official at USAID on conflict management, and has sizable experience working in conflict affected areas in fragile states, including Asia, Eastern Europe, and Africa. And she's going to talk to us about where we might go from here. So thank you, Liz.
So thank you so much for the opportunity to work through this problem. For those of you who know me out there, you know I always say, what is the problem we're trying to solve, and so what, and how do we do it, from a very practical approach. So I'm gonna skip through a lot of these slides because much of it has been talked about, but and look at it from the programming perspective and what Kay, as my co-conspirator on this, um, uh, how do we get a legislative material support fix? So as you all have heard, you know, these severe restrictions have been imposed by US laws. They are limiting the effectiveness of programs that have been designed to prevent people from engaging in violent conduct, violent extremism. I'll bring up the Sri Lanka example because it's been brought up. I was working for USAID at the time in the Office of Conflict Management and Mitigation, and I was, that was my region, and I was funding programs. And I would have to pick up the phone and call out to our partners and explain to them, no T for terrorists. So you couldn't even have a conversation with the LTTE. And I have been known to say, and I'm not going to jail for those conversations. And you know, this is going back into, you know, about 2005, for example. And our lawyers at USAID were very strict about it. So, you know, that was the chilling effect that David talks about. The counterterrorism laws have not kept pace with the evolving challenges. And, you know, understanding when these laws were adopted in the early 2000s, right after 9/11, we know that the intention was not bad. And the intention that Congress had, as you'll see by the exceptions that they put in the law, was not to have this a chilling effect. I firmly believe that. So next slide, Zach. Okay, again, you know, David has gone over this really well. But we firmly believe the US laws need to be amended or it will be status quo. And the Global Fragility Act lays out very clearly why it was adopted. We need to do things differently. And what I have been very clear with even our co-sponsors on the Hill is that if we do not amend these laws, it will continue to be status quo. Zach, next slide. And here's the current exceptions. Right now in the law state, with concurrence of the Attorney General, authority to create exceptions under personnel, under training, under expert advice or assistance, those could be exceptions that the Secretary of State with the Attorney General could exempt. They have never exercised this power, and I have been told by everyone within the State Department, a memo will never even reach up to the 7th floor on this issue. So this was the exception that Congress put in the law. We know it's there, and we know they won't exercise it. Next slide. So again, you know, the national security threats have evolved. The law has not. The criminal definition has not changed since 2004. We have the Holder case. We have gotten a lot better in terms of what we know drives violent extremism and how to program. Again, early in the 2000s, after 9/11, our strategy was to throw jobs at it, funding for jobs. You know, we know over the last 2 decades what drives violent extremism. Next slide. So the OFAC license process, you know, and that's one of the areas that we're told, go to OFAC. It's not a fast process. OFAC in the last few years has given a lot of licenses with humanitarian funding in the Middle East, for example. It is a incredibly long process, and it is a long process for someone who is in the government I worked on an OFAC license, and it took a lot of my time, and it was, you have to have a really strong champion within the government. But there's also numerous examples where it has been extremely difficult to get OFAC licenses. Next slide. So programmatic responses. This goes back to the laws haven't evolved, but our knowledge with over the last 2 decades really has. So we are getting there. We're getting some aggregated evidence of evidence of what works. We know what those drivers are, but we do need to get better at understanding what really works and what do we know to reduce violent extremism. Next slide. However, we're incredibly hindered by this law. We know that the research shows that grievances, it's linked to state and security force abuses, marginalization, injustice, social deprivation, desire for justice and purpose. The peace building field programmers have to be able to work with people that are coming out of these organizations, maybe sliding into these organizations, flirting with these organizations. As opposed to the DDR process, we have a clear line of how to start working with people. We know that if they put down their weapons, if we believe that they're not going to pick back their weapons back up, if they walk into a DDR camp, we can start DDR programming with them. We don't have any exception like this. Once you are on this list and once you are affiliated, it is impossible to get off this list. And what do we know about what is the primary driver of conflict? We know that conflict is a primary driver of terrorism. And so we need to be able to program against those grievances. Next slide. So this is a theory of change that AFP has been looking at. We've been trying to pull what we know from evaluations that are out there. So if we know this approach works, increasing community capacity to resist and mitigate violence. If communities feel that governments and security institutions are trustworthy, accountable, you can go through it, but you're gonna have to, at some point, you're gonna bump up against people in the community that, again, sliding into this area, coming out of these groups. And if you cannot program, we will not be able to address the grievances and also reduce violent extremism. Next slide. So here we are, moving forward. The Global Fragility Act, Section 50482, it requires the GFA to include the specific objectives and strengthen state-society relations, curb extremist ideology, and make society less vulnerable to the spread of extremism and violence. However, Section 504A12 says that the strategy also has to specifically address the risk of these programs, so you're not empowering corruption and or be exploited by extremists. So again, you have this dueling competition within the GFA. And next slide, Zach. So what has, my opinion back to Congress is that they've even gone farther than even what the laws have said that USAID and State Department has had to do. The vetting process has become increasingly draconian and expensive. Currently, there is this, the RAM office that is, and they've been running a pilot program that actually stalled some programs because they were looking at it just from a pilot perspective and they weren't, and other programs had to stop for a period of time. But you're looking at the cost of vetting, which is $400 per person, which comes out of program funds. Next slide. So It's time for a legislative fix. And that's one of the things that we've been looking at. And we believe that we can go in and put in some legislative fixed language, some exceptions that would not be too difficult to do. Next slide, Zach. So this would be looking at providing legislative protection for speech and communications intended to advocate for peace, establish the safeguards for DDR program, especially with child soldiers, and provide a legal engagement process for designated organizations that would want to work in peace processes. And then the last slide. So looking at the legislative fix, and that's something we'll be moving, that we are moving forward. We have a coalition. If you're interested in joining, please let Kay and I know. But there's something else that's just popped up really quickly on the horizon. And this is a new amendment calling for a bipartisan commission. And the bipartisan commission, which has been Representative Ingle, who was one of the co-leads for the GFA in the House, has put this commission, they're putting this amendment forward to look comprehensively, and two of the pieces out of it would be to assess how to adapt our counterterrorism efforts and review the legal and policy frameworks for counterterrorism. So this is something that we'll be working on to get this amendment passed in July. And then at that point, go forward and really focus in on reviewing the legal and policy frameworks. So with that, I'll stop.
Thanks so much, Liz. Now we can move into question and answers. I have a few myself. Others have questions, please put them in the Q&A box, and I'm going to read the one that's there. Asking, is there any indication that the Supreme Court would come out differently today because of new justices, new precedent, or a changed situation in the case? Now that we can demonstrate there are better ways to tailor the law or demonstrate the chilling effect.
You know, it's never say never, but I wouldn't count on it in the short term. I do think, I mean, there's just last week, the president designated the International Criminal Court as effectively as an international terrorist organization. He didn't literally use that term or that framework, but it's the same legal regime, and it now is a crime. It's now a crime and deportable offense for anyone to assist the International Criminal Court in investigating war crimes by U.S. people or our allies. I mean, it's an outrageous extension of this principle. And you know, if someone were prosecuted under that law, or indeed if someone were if a peace builder were prosecuted, I think, you know, the court may well come out differently. I think in my case, had my client, the Humanitarian Law Project, its director, a guy named Ralph Ferdig, who passed away a couple of years ago, but he was a former federal judge who was the head of this project. If he had been facing a 10-year prison sentence for doing what we argued he had a constitutional right to do, I think we would have won the case. It just would have been more concrete. It would have been more salient. And I'm quite confident that they would not have allowed a person to, you know, who was only supporting peace to sit in jail for 10 years. The fact that we brought it in advance because of the chilling effect, I think in some ways made, you know, on the one hand, we got injunction for over a decade, but on the other hand, it made it a little more abstract. So yeah, certainly the more the government overplays its hand, like with the ICC executive order from last week, the more likely you might be able to get a favorable ruling in the lower courts and ultimately in the Supreme Court. But I would focus on Congress, and especially if we get a different Congress in 2021.
This leads directly to my question, because over the last 10 years, often in our advocacy, government officials tell us that no peace building organization or no peace builder has been charged with a criminal offense, and that we're overreading the Humanitarian Law Project decision, and it's really a problem with self-censoring, and we should just get over it. Is this, what's the response to this? Is there wiggle room in the HLP decision that we're not taking advantage of, or is this an argument that we need to push back against, or both?
Well, so I think, look, the law doesn't make every contact with a labeled organization a crime. You can have a conversation with the PFLP or Hamas. You can advocate for the just cause that a international terrorist organization is advancing. You can even advocate for its use of violence and terror if you wanted to. Those are all constitutionally protected, and the government was very clear. Independent advocacy in support of these groups is not prohibited, and merely talking with the groups is not prohibited. When it becomes a crime is when it goes from talking to providing expert advice or assistance. But of course, that's a very, it's a very hard line to draw. And so many people who are risk averse will just not go there. And many, lawyers tend to be risk averse. General counsel of and nonprofits tend to be risk averse. And if they're unlikely to say, hey, look, what you want to do could land you in jail for 10 years, but it's not likely the government's going to prosecute, so go ahead and do it. Not many lawyers are going to say that, right? And that's just the reality. So I think it's not an answer to say there haven't been prosecutions, because the chilling effect is real. People abide by the law whether there are prosecutions or not, and particularly where the penalty that they face if the government chooses to prosecute can be 10 years or 15 years in prison.
And I would just add, I 100% agree, David, coupled with the fact that when the government won't even use their own exception, and also they're increasingly, the vetting requirements are getting much stricter within the U.S. government, that sends another message. And so I think those things combined, and then also with the False Claims Act and the cases that have been brought civilly, have also, I think a lot of people might have gone on a don't ask, don't tell. And clearly that was the message we got from the Obama administration, coupled with the DOJ memo that, did find its way, got declassified and found its way out. However, once you start also looking at the civil suits, what organization wants to be on the cover of the New York Times saying that they're providing support to terrorists?
Yeah, that's right. And the only other thing I would add is that, the administration, in the course of our, 12 years of litigating this case, at any point, the government could have said, oh no, peace building is not covered. And then our case would have gone away. But no, that's not what they said. They said peace building is covered and it's constitutional to make it a crime. So I don't think we're overreading it in that respect. I think some people do overread it in thinking you can't even talk to somebody who's part of one of these organizations. And that's not, you can, as long as you don't, in talking to them, provide them expert advice. And, if you're a lawyer, almost anything you say on the law is expert advice, so it gets pretty hard. But, independent advocacy and conversations are not prohibited per se. That's about it. Everything else is formally prohibited, and the government, including the Obama administration, took that position.
We have a couple of questions that essentially deal with the issue of who is really being targeted with this prohibition and with the position the government's taken. And by having this lack of clarity and this kind of don't ask, don't tell enforcement policy, are there certain groups that are being favored and certain groups that that they intend to restrain or have the chilling effect take place? And on certain types of activities. So throw that question at you, especially from the programmatic viewpoint. Do you see some types of programs getting more of a free pass, wink and nod than others, or is it more across the board?
So all I'll say is that the law gives, incredibly broad discretion, and the problem with broad discretion is it can be abused. And the nature, as we all know, one man's terrorist is another man's freedom fighter. So the very designation of a group is a political act that takes into account. It's not that every organization around the world that has ever used violence against property is designated a terrorist group. It's the groups we don't like are designated, the groups we do like are not designated, even if they're engaged in the same activity. So it's inherently subject to biased enforcement.
So David, again, 100% correct, because you know who isn't a designated terrorist organization?
Oh.
The Taliban. And why not? Because we knew at some point in time that you'd have to have a political agreement with them.
Mm-hmm.
So if anybody should be on the terrorist list, one would argue it would be the Taliban.
Yeah.
Since you brought that up.
And why is the FARC still on the list now that there's a peace agreement? Sorry, Stacey.
No, not at all. Since you brought that up, you've opened the door. I just want to reiterate what I said earlier about the kind of fear and lack of trust that this seems to send, in terms of the message to women peace builders. And in all fairness, it's not just the US. I mean, some of them have mentioned the EU countries as well, in terms of thinking about funding their work. But, women peace builders, they're the ones on the front lines doing this work, taking the risks and, putting themselves, in their own protection at risk and doing this work. And, with regard to the Taliban, Afghan women have been negotiating with the Taliban for years. I find it not just interesting, a bit infuriating that they have not been included in the US Taliban talks, and that we are still having this same conversation around fighting for their meaningful participation and inclusion.
So
We're
Kay, I apologize, but I have a 2 o'clock another call, so I have to run. But again, thank you so much for doing this.
Thank everyone, because we have run out of time. So thank you, David.
Bye-bye.
And this webinar is being recorded and will be posted on our website along with the PowerPoint slides, and we will take the questions we haven't had time to address here and get back to you via email with those.
And also, we encourage people to join the coalition. And Kay, you can provide that information.
There is a solution to this problem, and we can get there.
We'll fight for it. Thank you, everyone. Take care.
Thank you, everyone. Bye.